Okay, good afternoon, everyone. Welcome to this Workforce Wednesday webinar. My name is Kirsten Bayer with the Illinois Center for Specialized Professional Support at Illinois State University, and I will be on for moderation and facilitation today. Today, we will be talking about WIOA Dislocated Worker Eligibility, and we are joined by Jim Potts and his coworker, Raymond Al Amin.
Lost you, Kirsten.
Oh, can you
Oh,
hear me?
yep, now I can.
Okay. Um, so I was just introducing myself here. Yeah, it says my internet connection's unstable. I'm not sure why.
Well,
Um,
I can kind of take over if you're wait if you want, Kirsten. Uh,
um, sure, you can.
okay, it's, Kirsten does a great job helping us set up the webinars, and today she's with the Illinois Center of Specialized Profession at ISU, and they do a lot of the webinars, and she's going to help with my slides and any other questions. One of the things, there's a poll. I'd like to know where everybody's from. So if you could pick out your LWIA and identify where your LWIA is from, either the Chicago area, Northern Illinois, Central Illinois, Southern, or if you're statewide, maybe you work for DCO, IDS, or IDHS. We got some folks, I think, signed up from there. So go ahead and feel free to respond to what's appropriate for you. And let's go ahead and see what those results are. Kirsten. So it looks like a good variety. The folks from Chicago, we had their own webinar last week on the 3rd because they have the Career Connect system. So I expected fewer folks for that. And then it's a good disparity elsewhere. So thanks, Kirsten. Next. We got to take down that poll for a second. It's still up. Oh, duh, I got to close it. That wasn't on you guys. That was me. We're going to talk now, which partners do you best represent? So you have all the various choices. And so there's going to be a lot of choices on the poll that'll come up. So go ahead and bring the poll up for us.
One second. I'm not sure.
That's a lot of choices there. So it's
There we go.
it still doesn't seem to be coming up. Oh, there they are. All right. Everybody hopefully has had time to give us a little feedback of which partner they represent. So let's see the results. And just was that kind of expected, primarily Title I WIOA, because that's what we're mainly talking about. Folks, our partners from IDS and IDHS, it's still good for them to know about our programs, of course. The presenters, my name is Jim Potts. I'm with the Illinois Department of Commerce and Economic Opportunity, and I'm in Springfield. And I'm getting ready to retire at the end of July. So Ray Alamin is also, he's a statistical research technician for us. So he's helping me out. And he's put together some really good stats that you're going to see later on. So if we have questions about that, Ray's on here. And I won't make him introduce himself, but at the appropriate time, he'll come in. So next slide. This is a slide I always give credit to people I steal from. So I got this slide from somebody else from Chicago. And what I really like about it, just kind of gives a little bit of overview if the person's newer to WIOA. So if anybody else wants to steal it from me when they're trying to explain it. So it's a federally funded program by DOL that helps people get back to work, basically, if you think about it. It also assists employers to find and train people for employment. And then there are universal services that's offered to everybody, like they can go into our resource rooms and utilize our services. But if they're going to be participants, they have eligibility requirements. They're broken down to the 3 main programs. And as you know today, next slide, please. Today we're talking dislocated worker, but yeah, the adult funding stream, dislocated worker, and youth. You'll hear us talk today about adults some because a lot of times adult and dislocated worker career planners work together. And then just a little bit of overview of youth requirements. So next slide. And then this is another slide I actually stole that kind of breaks down how the funding works. We receive the funds of Illinois from DOL, and then DOL breaks it down to the state breaks it down to the 22 different local workforce innovation areas. And then each LWIA, if they have subcontractors, they would have to divvy the funds out to those. So that's just a little breakout how the WIOA funding works. Next slide. I have a little bit of poll. This is just for my understanding of what the target audience. So I'd like to know your familiarity working with the WIOA programs. Have you been working with it for less than a year, between a year and 3 years? Are you more than 3 years? Or really you haven't worked with it, but you will be now? Or you haven't worked with it, but you just want to become more familiar. So if you can give me a little bit of feedback, I'd greatly appreciate it. And let's see those results, Kirsten, please. All right, so we got a few new folks, and that's exciting. And then some folks have been around a little while, but mainly folks have been around for quite a bit. So excellent. Thanks for those results. Appreciate it. Next slide. So today, the primary objective of the presentation is to inform you guys of the most intricate details around the current federal and state guidance for the WIOA legislation and dislocated worker eligibility. Secondary, though, we're going to touch on the importance of serving qualified dislocated workers under the appropriate title to ensure that we're accurately recording our WIOA clients. So next slide. Well, hopefully we're aware, those that work with dislocated workers, there was a policy that was updated on May 12th, 2023, and this is the state's dislocated worker policy. If you work the program, you have to know this policy. So, and again, it was put out in 2023. There were quite a few changes in 2023. It really broadened the eligibility criteria. But we'll talk about that during the presentation today. So next slide. Where do we get the reason to provide dislocated worker? It's through the WIOA legislation, and it came out in 14. It was effective July 1st, 15. And then DOL puts out federal guidance, and they're called Training Employment's Guidance Letter, TEGLs. So that's the secondary direction from Department of Labor. And that was put out in May of 17. So if you think about it, the WIOA legislation, they had about 2 years where they got feedback from the field. So they sent out the TEGL to get clarifications on things. There's been an updated TEGL, but it's primarily for the adults. It's about priority of service and putting out the percentages that's required. So this is really the latest dislocated worker guidance from DOL is that March 17th or March 2017 TEGL. So then for the state policy, we have general eligibility and then selective service, because any guy and person born male would have to be compliant with selective service. And then dislocated worker, the eligibility policy we spoke about was put out in May 2023. Next slide, please. And then really important is your local policies, because besides the federal and state guidance, each local workforce innovation area has the latitude to establish their own additional local policy. And this was one of the pretty significant changes that was put in the state's policy in May. And some examples, it allows each LWIA to establish a local policy, and that's approved by the LWIA, that it can determine what occupations or industries are considered significant to the LWIA, as defined by the LWIA. An advantage of that is anybody that's or any occupations or industries that are identified in that local policy can be considered a substantial layoff for eligibility. And if you don't know, we'll talk about later how much easier it is to make somebody eligible for dislocated worker under substantial layoff. So again, this is just an example of what a local policy can or cannot do. Now, if you're not familiar with your own LWIA's local policy, it's essential that you work with your supervisor or manager to become familiar with those details. Next slide, please. So we have a little poll about this. So regarding your local workforce innovation opportunity or areas tailored dislocated worker policy, there's 5 different choices. If you could read those and just give me feedback. This is anonymous, so tell me how you feel or what your response is. Are you familiar with it, the details of it, and you reference it? You know your LWIA has a policy and you clear out the patient. I know my LWIA has policy. If you're not that current with it, or you're not familiar because you may not have one, or you do not work with the LWIA, so you couldn't have a response. So,
Hey Jim, your voice is cutting out towards the end there. I don't know
all
if
right,
it's
I'll pull a little closer. I might have been moving back, so we'll try to do that. So,
all right.
thanks for the update. Appreciate that, Michelle and Ray. Go ahead and give me the results of the poll, please. Okay, so some good feedback. See, I was kind of surprised or not surprised, wondering because some LWIAs don't have a local policy, and or not all LWIAs have local policy. So I almost thought that the fourth answer would have a little higher reply, but I'm really thrilled with the numbers there. So appreciate that. So now we're going to talk, as I touched on earlier, general eligibility. All clients have to be authorized to work in the United States. And then also, all persons have to be, if born male, they turn age 18, they have to be compliant with selective service. So that's general eligibility. Next slide, please. And then for dislocated worker, we break it down into 6 separate categories. You have unlikely to return to previous industry occupation, plant closure or substantial layoff, UI profilee, no longer self-employed, displaced homemaker, or spouse of a member of the armed forces on active duty. Each of these have distinctive eligibility criteria, but a lot of times you'll see that they'll overlap. And we always want to make eligibility what's easiest for the client as far as documentation and what's easiest for you as the career planner working with the client. So you always keep that in mind. What's easiest for both parties to get this person that is an eligible dislocated worker? I don't know how many are familiar with it, but part of the dislocated worker policy that was put out in May of 2023, a checklist was added. Now, the monitoring folks aren't requiring you to have or the policy doesn't require you to use the checklist, but it's a really handy at-a-glance tool that you can use. When I conduct in-person WIOA eligibility training, I always want to include that because eligibility for dislocated worker can be really layered in some sense. So having this checklist as an at-a-glance tool is really handy. So I'd encourage you to keep one around for yourself. So next slide. As I touched on earlier for LWIA 7, all the people downstate, outside of the Chicago Cook area, use Illinois Workforce Development System. In the folks for LWIA 7, they use Career Connect, which is a separate system. Effective whenever we get IWDS 2.0 completed, we're all going to be under the same umbrella using it. But until that time, we do have 2 different systems. And again, I've done the LWIA 7 training on the 3rd, and because I tailor the training with screen prints to show where it's appropriate. So those LWIA 7, make sure you reference back to the training on the Zendesk that'll have the tailored for Career Connect. And then again, everything today we'll be talking about IWDS. So next one. And then that's what I've got another poll. If you could identify which management information system that you use when you're working with WIOA clients. Now, you could use IWDS, or it could be Career Connect, or in some instances, it could be both. Like we have folks from National Able Network, they have to use both if they work the trade program and some of their national dislocated workers. And then our monitors, they often have to work both in Career Connect and IWDS. So if you could fill out whatever's accurate, I'd greatly appreciate it. And this is the last poll, just so you know, you don't have to work anymore after this. And then let's go ahead and see the results. All right, excellent. That's kind of what I was expecting, is the majority of IWDS. And again, for those for LWIA 7, you're more than welcome to stay on, but this is tailored to IWDS, and the presentation on the third was tailored to Career Connect. So you'll hear the same thing, you just see it a different way. So next slide, please. The training, this was about those Career Connect folks from for LWIA 7. Here's a direct link that's to the webinar for some reason why you wouldn't have it. Also, these slides will be available on the Illinois WorkNet site with the recording of this presentation within 48 hours or approximately around 48 hours. So next slide. So before we get into the dislocated worker eligibility, what I'd like to do is make sure we're all on the same page of three different terms. And these are really essential that anybody who's working with the dislocated worker understand. The term underemployed, the term self-sustaining employment, and then the term intervening employment. Really three key terms. So let's go ahead and discuss these individually. So next slide, please. First, underemployed. In the WIOA legislation, it's actually defined as someone who's working part-time but desires full-time employment, or someone who's working employment not commensurate with the individual's demonstrated level of educational attainment. So I'm working part-time, I want to work full, I can't find a job, I'm underemployed, or I've got myself an advanced degree and I'm flipping burgers at McDonald's. So those are even any sort of degree, I guess, when you're flipping burgers at McDonald's. So that could be considered underemployed. Next slide, please. But DOL put out in TEGL 1916, the guidance for dislocated workers, that if anybody is an adult or a dislocated worker and they're on food stamps, they're applying for the program and they're on food stamps, so public assistance and cash welfare, even a medical card, they should be considered underemployed. That makes sense. If I'm working a full-time job, but I have to have a medical card or have to get food stamps, well, I need to get a better job. So that's part of the definition. So next slide, please. I've seen the tone. I'll try to speak up and lean into my speakers so it doesn't appear my headset may not be working correctly. So underemployed again in the TEGL 1916, they broadened it to include not only folks that's on the public assistance, but anybody that's determined low income for any way if they're working full-time should be considered underemployed. And then another one is individuals who are employed, but whose current job earnings are not sufficient compared to previous jobs earnings from the previous employer. Now, what this is similar is to a lot of our local workforce areas. All right, thanks, Kristen. A lot of our local workforce areas have self-sufficiency criteria for a dislocated worker based on the individual finding employment equal or greater to a percentage of the client's dislocation wage. Like I did that training with Chicago last week. They have a really excellent self-sufficiency policy that states for an individual to become a dislocated worker, they must make as much or more than their dislocation job. So that's what they're trying to get them back to. So that's what you're going to base your sufficiency on, is if we can get him or her back to full-time self-sustained employment. So next slide. In IWDS, we capture underemployed. It's on the employment characteristics screen. Down at the bottom, it's a yes/no question. So the client might not know that, so you'd have a discussion with him or her about their circumstances. Now, it wouldn't be possible for somebody who's unemployed to be underemployed, so they'd have to be currently working to meet that criteria, and we have that logic in IWDS. That they have to have something other than unemployed or not labor force in order to be considered underemployed. So keep that in mind. This doesn't have any direct eligibility criteria tied to the logic in IWDS for that underemployed, but you are getting credit for a barrier to employment for all titles. So if you're working adult, dislocated worker, or youth, if the person's underemployed when they're applying, I encourage you to record that. You don't have to have anything more than just them explaining their circumstances. It's not like there's formal documentation for it. It would just be their circumstances that they meet that underemployed criteria. So next slide. The next one I want to cover is self-sustained employment. I kind of let the cat out of the bag. We talked about in that last slide where an LWIA defines this definition for a dislocated worker. And it's typically defined by a percentage of a layoff wage. Sometimes it's 80%, sometimes I've seen 90, 95, and the LWIA 7, the 100%. There's been talk about the state, since each LWIA is different, for an equity basis to make it a statewide. So that's some of the discussions I've heard. Don't know if it's going to happen. I just wanted to pass that on. But again, you'd find this out from your own local policy. And for every dislocated worker career planner, you have to know this, because how else are you going to know what you're trying to get your client back up to if you don't know what your own self-sufficiency policy? So again, find this out. And where this really comes into play are for your high earnings clients. Like if somebody has a $100,000 a year job and they lose that, and they have a lifestyle that they're used to making a substantial income. And if we say, well, you can make do with $40,000 a year, that's not going to work for that person. So that's where if you have that local policy that says like 80% of the dislocation wage. So that person that got laid off making 100,000, if the local policy was 80,000, well, if we can get him back to 80, he or she's 80% there. Or like the Chicago policy, it's 100%. I got laid off making 100,000, applied for dislocated worker, met criteria, was put in services. I would be a qualified dislocated worker until I at least made a job making 100,000 or more with this example. So again, each LWIA should have their own policy that breaks this down. So next slide. And then I just touched on that. So next slide, please. Next, we'll talk about intervening employment. Intervening in employment is when somebody takes a job that's less than what the self-sustaining employment is. So using that last example of LWIA 7, you have a client making $60,000 a year. That individual is hired into a job making less than $60,000 a year. So that would be intervening employment. The advantage of this is this person could still come back in to apply and receive services under that original dislocation, even though he or she's working now, because they're under self-sufficiency. So that's one of the advantages of understanding this intervening employment and self-sufficiency and underemployed. So next slide, please.
Jim, will we be able to go back to a question concerning underemployment?
Sure. Yeah, go ahead.
This is from Lisa, and the question is, we do not need documentation in file for this, correct, concerning underemployment?
Yep, correct. I mean, you'd want to, and I'll give you, we're jumping ahead a little bit, but there's two portions of eligibility criteria that directly relates to underemployed. It's spouse of an active duty service member that has underemployed include, and displaced homemaker, which has underemployed include in the criteria. If it's going to be used as part of either of those criterias, then we'd have to have the more formal documentation. But if it's just a client who's an adult or dislocated worker or a youth, that it's just a circumstance of their situation that they meet the criteria of underemployed. Nope, you just check underemployed, and their circumstances should support that. Hopefully that answered the question. Anything else that's there, Ray?
Nope, that's it at the moment.
All right, thanks for bringing that up. Appreciate it. And good question, Lisa. Thanks. Where was that? Okay, next slide from the intervening employment, please. So if you're currently working as a career planner with the dislocated worker population and you do not currently know your own LWIA's local policy or guidance on self-sufficiency for dislocated worker, you have to get with your boss and find out what that is. That's the only way you know how what I'm trying to get my person up to as far as self-sufficiency. And again, without you knowing that, it's really extremely difficult for you to reach that overall goal for the client to become full-time self-sustained employed. So next slide, please. So to tie everything together on these topics, if a client had intervening employment, they would be considered underemployed. And then the client could still have consideration for their eligibility under the dislocated worker program using that original dislocation job while working at intervening employment due to being underemployed. And then lastly on this topic, a client would be working in intervening employment at any job until they obtain self-sustained employment. Again, we're trying to get folks back to self-sustained employment. If they're not at that, their dislocation job would be the last time they held that. So you can go back in time. The only way you couldn't is if your local area had what's called a look-back period, which I don't think anybody has. That was something that was part of previous legislations, and it restricted the ability to go back in time a certain amount to determine dislocated worker eligibility. Now we don't have that. Your eligibility should be based on the last time the client had full-time self-sustaining employment. That would be his or her dislocation job that you'd be trying to get them back to self-sufficiency from. So next slide, please. So now that we've covered those terms, let's get into the specifics of dislocated worker eligibility. As mentioned earlier, an individual could meet 6 different categories and become eligible. But whenever they're certified under 1D, 1E, 1N, 1S, and if you co-enroll in trade, 1D. So if you're certified under any of these 6 titles, next slide, please, you meet eligibility for 1D. So you don't have to be certified in multiples. All you have to do is certify them in one. So if they meet it, again, I highly encourage you always to use what's easiest for you and the customer, you as a career planner and the customer. So of the 6 different ones, unlikely to return to previous industry occupation is by far the most difficult and layered. So I like to take care of difficult first. So we're going to knock that one out. So next slide, please. Yep, next slide. There's something that's very important that first everyone must understand. If you're working as a WIOA dislocated worker career planner, that across the state, we're serving significantly less dislocated workers than adult. And I'm talking significantly less. It's like 25% compared to the 40, 45, 50% of adults or higher. There are concerns that there are potentially qualified dislocated worker clients who are being served under the adult title just because it's simpler. Sometimes if somebody's basic skills deficient, you can certify them under the adult and not have to deal with the dislocated worker. We can't do that. We have to make sure that if you have a qualified dislocated worker, that we're serving him or her under the appropriate title. So this next slide, Ray Alameen, the statistical analyst, put this together, and it's out of IPATS. And he put it together as of Monday, and it lists statewide, and then by each LWIA, where we're at for total active participants, and then how those break down to the adult count, the percentage of clients that's included under the adult, youth, and dislocated worker, where are we at with the title, and then the count for dislocated workers and the percentages. And as it's showing, for the statewide, we're at only 25% compared to 43% adults. And then each LWIA breaks out. Kudos to LWIA 1 and LWIA 18. I've reached out to both of them. Damar Harris, who oversees the dislocated worker with LWIA 1, and Chuck Jones with LWIA 18 to find out what's their secret. And I would encourage you to, if you're not serving as many dislocated workers as you'd like, to reach out to those LWIAs that are serving more. They're doing it. So we got to find ways, because some of the impacts, if we're not serving dislocated workers, we have different funding that comes from, besides the formula funds, that we can get additional dislocated worker funds, whether it's through 1E rapid response or through national emergency grants that periodically come up for not only when floods and tornadoes, but due to economic emergencies can come out. But if we're not spending dislocated worker funds ourselves, then it's hard to go in to ask for additional funding. And I'll just give you an overview. LWIA 18, who's serving, look at that, 91 dislocated workers to 49 adults. And Chuck had said, well, they had a big layoff for a factory in their area, Quaker. But, all areas have layoffs. It happens. But Chuck's found a way, him and his team, to get the people to come in to get services. And they had about a 20% of people laid off that came in to get services. So they're doing a tremendous job with outreach in that. And he gave me other ideas of how how they've been successful upping their numbers for dislocated workers. But here's how we they don't, it's a small LWIA, it's over in Vermilion County, and they don't get a huge chunk of the WIOA formula funds. So overall, they've only been spending about $230,000 a year on dislocated workers. But due to increasing numbers of people served, and the last two in 2022, program year 2022 and 24, they've got 1.3 million in initial funding to help serve these clients that need the dislocated worker services. So it's showing how doing this can get you more funds, you can serve more people to help your LEA. So you guys can see the numbers there. This is from the IPATS dashboard, the Illinois Performance Accountability Transparency System. It's a great tool. When we go to IWDS 2.0, everything's going to be instantaneously hooked up to the dashboard. It's a great way. And if you're not utilizing it, I highly encourage you to get a WorkNet account and get access to IPATS, because you can drill down all the way to the career planner level and you can see your clients, the effective performance. There's a lot of stuff you can do on the IPATS dashboard. But this slide was put together by Ray, and I appreciate him doing that. So next slide, please.
Jim, if we have a moment, we have another question in the
Sure.
chat. And this question is from Annette. And the question is, what's the difference between intervening employment and the underemployment criteria that states a participant is working part-time but desires full-time?
Yep. It's really one and the same if you think about that, because there's a bunch of different portions of underemployed that gives you that definition. And just as you had mentioned that working part-time desires full-time. So if somebody comes in, and I'm just thinking like a client, like I'm your client, and I walk in the door, and I said, yeah, I'm working at McDonald's, but I can only get part-time work and I can't get full-time. Well, then if I was applying, and maybe I said, I'd worked before at J.C. Penney's here in Springfield and it closed down, and now I can't get a full-time job, so I'm just working this part-time. So you could mark me in my application as being eligible under plant closure due to J.C. Penney's, but I'm working currently as McDonald's, and you could check underemployed because I'm working part-time. So that, hopefully that answered your question, Nat, but that's kind of a practical of when that would get tied together. But if anybody comes in and applies for their services, if they're working part-time and they want full-time, that's underemployed. Now, that doesn't mean they're automatically qualified as a dislocated worker. They still have to meet eligibility, but that's when you'd go back to previous employment he or she might have had. This next, there's a Microsoft tool that our folks with the performance unit has worked with the people with Northern Illinois University, and really had got on and done some really good research for the past 4 program years. And this is just for us as a state. It's not the information for each LWIA, but Ray has also done the legwork. He's went in each LWIA, he's broken out by program year 2021, 22, 23 using this data. And then he's used the IPATS data for PY24 currently. And we have all that broken out. And if we get time at the end, we're going to go through that and look at it. But if we don't, and even if we do get through it, I'm going to send out each LWIA's information to their contact for the dislocated worker that I received from Kelly Lapatino, who's the Northern Regional Manager. And I'm going to send that individually to you, and either pick your brain of what you're doing to make your LWIA doing so well, or give you some ideas, or be a sounding board for ideas to maybe increase your numbers if needed. But this kind of shows, back to PY20, look at the numbers of dislocated workers being served. At that time, we had 2,900 dislocated workers, new registrants, and 3,800 new dislocated worker registrants and 3,500 adult registrants. So our numbers were larger for a dislocated worker. And then we had the next year, it started changing a little bit in PY21. We had 3,900, but there's more adults. Now the last 2 years, it's creeped up. This year, it's way higher adults than dislocated workers, as you've seen on that last slide. So what's going to happen if you just think about this funding, if DOL looks at it from the outside, they're like, Illinois doesn't have any dislocated workers. It doesn't know what's going on. So you can look at decreasing funding and things like that. So it's really important that, one, we find qualified dislocated workers, but two, we got to serve folks under the right title. So it's really imperative that we do that also. So next slide, please. So again, now I'll give my spiel about how unlikely to return is the most layered. And we're going to go over that first. And instead of saying unlikely to return to previous industry or occupation each time, we're just going to call it unlikely to return. And it's layered eligibility. That's what kind of makes it confusing. It's very, very layered. So let's go through that. So next slide, please. And this comes right out of our state policy. It's actually mimicked out of the federal guidance, but we adjusted a little bit. That has been terminated or laid off or received a notice of employment termination or layoff. And this would include an individual who is separated from or has an impending separation from the armed forces. And next slide. And, and here's the key that a lot of times seems to be a stumbling block. The person is eligible for or has exhausted their entitlement to unemployment compensation as documented in one or more of the following ways. And then it breaks down about the classification. This is all legal talk. But what this really is saying in this paragraph, it's all legal talk, is if somebody worked at a job that paid into unemployment, they must be eligible to draw a monetary UI benefit. That's what that's saying. If I worked at a job that paid into unemployment and my employer denied my unemployment, it's impossible for you to serve that person under unlikely to return. That's one of the keys, what I talked about. I don't know if you remember earlier, when I said a local policy can determine substantial or significant jobs in the local area. Well, those folks, if you have substantial layoffs, we don't care about UI, or plant closure, we don't care about UI. Unlikely return, if they worked at a job that paid into unemployment, they have to draw a monetary benefit or exhaust their monetary benefit. That's the first layer of the eligibility. Next slide, please. And that's just the layman's terms what I just explained. So next slide. Next slide, please. Just a little bit about UI. This time's kind of went away about PUA, but traditional UI payments are received when an individual loses their job where the employer of record had been paying into UI system on behalf of the individual. When the individual applies for UI, as long as the employer does not dispute the UI claim, then the individual is able to draw their UI benefit while they're looking for employment. Used to be they'd extend benefits past, but now it's pretty much maximum of 6 months if you have that, if you've got worked and have that in your bank. So there's also something that's called PUA, Pandemic Unemployment Assistance. That was back when the economy got shut down, but that ended in September of 2021. If you ever work with a client that they haven't been working a long time, but they were on PUA when it ended, you're supposed to treat that just as if they had exhausted unemployment. So keep that in mind. And but you're not going to find probably too many any longer because it ended in September of 2021. So next slide. So regardless if the individual was fired, quit, laid off, if the individual is determined to draw a monetary UI benefit or exhausted their monetary UI benefit, the criteria to UI is met. So I get a lot of questions about this, like, hey, this guy got fired or they quit. It says on the printout from IDS, but they're drawing a benefit. We don't care. For your documentation purposes, if they're drawing a monetary benefit, they're going to meet the criteria. So all you're looking for, are they drawing a monetary benefit or have they exhausted? So, and do keep in mind, this is only part of eligibility criteria that are unlikely to return. All the other dislocated worker eligibility we'll talk about later, UI is not part of the eligibility, just unlikely to return. So next slide. I touched on that PUA. I thought I'd take out these slides, but in 2021, that's when they had the pandemic unemployment assistance, and that ended. And that's what the folks with Department of Employment Security said based on UI law. If somebody was drawing PUA when the program ended, it would be considered that they, even if they had a balance left, that they exhausted the benefit. So next slide. And this is where in IWDS, where we classify, and this is where the logic is looking for certain responses for unlikely to return. A UI status for somebody you're thinking should meet the unlikely to return. If they worked at a job that paid into unemployment, it has to be either exhausted UI, eligible but not receiving benefits, or receiving benefits. Whatever response you say, you have to have documentation to support that. If it has not eligible, not determined, then it wouldn't be possible for the person to meet unlikely to return unless they meet what's called the alternative UI called tenure that we'll speak about in a moment. So next slide, please. So to recap, the initial eligibility for unlikely to return to previous industry occupation, it requires the client to draw a monetary UI benefit or exhaust their UI benefit, as covered on the previous slide. In addition, there is an alternative UI for individuals who work for an employer who had not paid into UI on their behalf, and this is known as tenure. So next slide, please. So where it's mentioned in our policy, it's got another legalese statement in our policy that tenure has been employed for duration sufficient to demonstrate attachment to the workforce, meaning the individual must have at least 30 days of employment in the industry or occupation from which he or she was dislocated, but is not eligible for unemployment compensation due to insufficient earnings or having performed services for an employer that were not covered under the state unemployment compensation law. So in this, so as long as your client who's applying for services, their dislocation job, if they worked over 30 days, and if they had not paid into unemployment, or if they had insufficient earnings, you could consider that as meeting the alternative to tenure. So one of the things I would like to point out is one of the changes in that policy that was put out for dislocated worker is they changed the tenure. It used to be 6 months. Now it's been changed to 30 days. So that lessened the time a person had to be employed in order to be considered a dislocated worker. So now if a person has a job for at least 30 days, they lose that job, you can look to use that job as a dislocation job. So next slide, please. Again, tenure is for an individual who worked at a job or in the industry for at least 30 days where the employer did not pay into the UI system on behalf of the employer, or is for an individual who worked at a job or in the industry for at least 30 days and had insufficient wages to draw a monetary benefit. Next slide, please. However, if someone worked at a job that did not pay into unemployment, and if they worked at least 30 days at the occupation and or industry, they would meet tenure. Again, 30 days is one of the things that we'd found out. If somebody works at a short term of a job, it's almost impossible. It's going to be impossible for them to draw unemployment because they're required to in order to draw UI, you have to have at least $2,000 wages in 2 of the last 4 quarters. So if I only work at a job for 30 or 40 days, it's impossible for me to earn enough money to draw a UI so then I can meet that tenure. So that's what you'd find with a lot of folks who have some short-term employments that they're coming in as a dislocation job. I think I seen a question pop up there, Ray.
Yes, so we have a question from James Wills. And so his question is, does tenure count for an individual that was fired or quit the job?
Great question, James. So if the person had worked at a job that paid into unemployment, and then it definitely was because the person's going to go apply. But in this circumstances, so if you're saying it's my dislocation job and I get fired, so I really don't have that, because if you think about how the IWDS works, they kind of give the person that's fired a latitude to say, hey, that was wrongful. I got wrongfully terminated, and they award you UI. Well, you really don't have that option in these circumstances where somebody has that did not pay into. So, you know what, James, I've been doing this for 19 years, and that's the first time somebody's asked that question. And I'm going to actually pose it to our policy folks. I want to get a firm answer. I don't want to give an answer that's not accurate or how we're going to put it in our policy. So I appreciate that, James. You gave me a question I've never had. So Ray, make sure to jot that down. And right after this, we're going to send it to policy and get you an answer. And we're going to make sure everybody gets that answer because it's really a good one, especially since we've changed the policy to make it you only have to work at a job 30 days to be a dislocated worker. We have nobody that really could give that ruling to, if maybe I quit because it was just horrible circumstances or somebody's doing something incorrectly. So I'm going to find out, James, and we'll get you an answer because I technically don't have one and I don't feel comfortable just giving what I think. I think we need to find that out. So we're going to research that and get back with you, okay?
And if we could continue with the questions, we have another from
Yep.
Antonio.
Yep.
And this one is, for tenure, does a person need to file a UI claim and receive a determination letter?
Well, that's the reason why I really encourage you to understand this definition, because we don't want to make somebody go file if they have no ability to draw. So again, some of those things we spoke about, if they worked at an employer that did not pay in, there's no reason for them to file. But if they had if they had wages, if they had more than 2,000 a month in 2 of the last 4 quarters, yes, you can't put them in under tenure unless they apply, because part of the eligibility is they have to be determined eligible for it. So it wouldn't be appropriate to even look at them for tenure, because you'd be expected to show, if you put tenure, how the person did not have enough income to apply for UI or draw insufficient wages, and or if they worked at an employer that did not pay in. So yeah, and they need to apply it, because also if we're going to put them in services, we want them to have that money that they can utilize while they're going through our WIOA services, because they're entitled to it. Next, any other question for you?
Yes, let's see.
We'll have other times, so you can look them over and see where it comes up, because a lot of times tenure questions do come up. And here's one: often people who separate from the armed forces after their enlistment, so when they get discharged from active duty, they're not eligible to draw UI. And if that's the case, we've gotten feedback from Illinois Department of Employment Security that those people, as long as they served at least 30 days in the armed forces, it would be appropriate to indicate them as meeting tenure criteria. So again, anybody that gets out of the armed forces, they're always going to be eligible as a dislocated worker if they have not obtained full-time self-sustaining employment. So it's yes to tenure, and then they will always meet unlikely to return criteria. So next slide, please. And where tenure is indicated, it's also on the employment characteristics screen. So of course, if somebody's UI was drawing benefits, you couldn't say yes to tenure because it's the alternative. So that's where it's captured. That's where the internal logic, how it's worked for unlikely to return. It's looking for the person to either meet the eligibility for drawing UI or exhausted UI or eligible but not receiving, or tenure. They have to meet one or the other in order to meet unlikely to return criteria. So for this client, this example client, he had gotten out of the Air Force after serving his time. He was medically discharged and he was not eligible for UI. So he met the alternative to UI called tenure. So next slide. Some other jobs examples, churches, religious organizations, the railroad, they have their own UI system. Insurance agent, don't think like big State Farm. I'm talking about like mom and pop insurance agency. Typically nobody's paying into UI on their behalf. Agricultural labor, people that's working for farmers. Domestic help, au pairs, housekeepers. More than likely nobody's paying into UI on their behalf. A lot of small family businesses might not pay into UI. A buddy of mine, he is an insurance man. He worked for his father-in-law, and things got tough, and his father-in-law let him off, or let him go. So he wasn't eligible for UI. So that's some of his circumstances. Many of the jobs that did not receive or that received PUA, pandemic unemployment assistance during COVID, would have been tenure jobs. Like my wife, she was a hairdresser and she owned her own shop. Well, she had to close down. So that's when PUA came in for those type of individuals. So next slide, please. Again, it's important to understand that under unlikely to return, if an individual is laid off or fired, quit, etc., and the employer had paid into UI system on behalf of the individual is or has been denied UI benefits, the individual cannot be determined eligible under unlikely return. There's no exception. I get a lot of questions about, well, what about this? What about that? If they paid in unemployment and they had sufficient wages, they have to be eligible to draw a monetary benefit. And that'd be the expectation for your documentation. So when a monitor's out, if the person's been certified under unlikely return, they're wanting to see that this person was eligible to draw a monetary benefit. So if I'm in the rears and I'm not getting paid because I owe a debt, you have to have documentation that shows they're eligible for a monetary benefit. If it says that on the printout, you can use it. If it doesn't say that, you can't use it. Typically, when they're in the rears, I had a question last week that asked about, I guess there's a way they could take child support out and then not give it to the member. I didn't know anything about that myself, but the responsibility for documentation would be to be able to show the client is eligible to draw a monetary benefit or they exhausted it. That's the eligibility criteria. And I want to keep in mind, as I touched on earlier, this is only needed. UI is only part of unlikely return. It has no bearing on plant closure or substantial layoff. So the more people we can put in under substantial layoff, the less we have to worry about this UI status. So we're going to talk about that in a moment here. Do we have a question, Ray?
We do. We have a question from James. The question is, when looking at military, does
Yep.
that apply to the Army National Guard as well?
If it was their full-time job, Ray or James. So because I know like here in Springfield, we got active reserves and active guardsmen that are working full-time jobs. So if they left that line of work, it would be the exact same way. But if it was the part-time, like if I'm in the guard or reserves and I work 2 weekends a month and 2 weeks a year, and that's not a dislocation job because that's a part-time job. It's got to be their full-time self-sustained employment. So I'm glad you gave me an easy softball I could answer there, James, instead of one of them questions that tripped me up. So next slide, please. So the next thing we got to look for unlikely return, they're not eligible just because they've been laid off and they're on UI or meet tenure. The next we have to look at their dislocation job. So for unlikely to return, we're wanting to see, was that dislocation job from a low growth industry as defined by the NAICS, the North American Industrial Classification System. That's where it gets loaded when you're recording a job in IWDS. Down at the bottom, you put in the NAICS. The next slide, please. As well as what's called the ONET for the low growth occupation. One of those, either the declining industry or the low growth occupation, has to be a yes. And it kind of makes sense if you think about it, because if I lose my job from a place that's not declining or not low growth, the thought is, well, why couldn't I just go find another job because it's an occupation that's undermanned out there. But that's what you're looking for unlikely return. You're looking, were they laid off? Are they drawing unemployment if they paid into it, or do they meet the alternative to unemployment? And then next, are they from a declining industry or low growth occupation? That's the dislocated worker so far for unlikely to return. Now, let's say you have a person that met all the criteria until you got to the low growth declining. Their job wasn't low growth and it wasn't declining because I was a registered nurse and I lost my job. And I can't go back to it because I have some medical issues now. So that's where, next slide, please. That's where we have this thing called requires additional assistance. Oh, this is just demonstrating where the declining industry and low growth shows up on the IWDS record. So you're looking for one of those to be a yes for your dislocated worker unlikely to return when you're recording their dislocation job. So next slide. Jumped a little bit ahead of my storytelling. But this is what we're going to talk about is if somebody's from a dislocation job that's not from a low growth occupation or declining industry, but you as the career planner have talked to them and you know their circumstances. And like the situation I was describing, I was a nurse who lost my job and I can't go back to it. Maybe I have a medical issue or something legal issue that I can't do that work anyway. Well, you could justify in the assessment why I require additional assistance. Nobody else can do it. You would have to explain it. It's had to be in your case note. And that's what a monitor, anytime you check, next slide, please. Anytime you check yes to the question of requires additional assistance, it's really asking, is this a dislocation job? It's not low growth declining. So why can't this person go back? So you have to explain in your good descriptive case note of why he or she can't go back. So next slide, please. And in IWDS, well, in our new policy that was put out, well, it's not new now, it was put out in 23, the policy lists a whole long laundry lists of possible reasons somebody might require additional assistance. This might not be appropriate for some of your clients, and maybe it is for some of your clients, but if you say yes to require additional assistance, you have to be able to support it. And again, these are some examples. They're not all inclusive. If your clients have another circumstances for it, you could record that, but this is just some examples. So next slide. And where this is tied together in IWDS, it's on the top of the dislocated worker characteristics screen. There's that question, requires additional assistance. Notice it doesn't have an asterisk by it. That means it's not required. So you only want to use that question when you need it. So the only time you need it is if you're going to make the client eligible under unlikely to return to previous industrial occupation, and their dislocation job is not from declining industry or low growth occupation. That's what you would have to explain. Because when you put a yes to requires additional assistance, then that puts you on hook to justify why you check that yes. And then you have to explain why the person's not able to go back to his or her job. And that's what a monitor is looking for when they look for this criteria that's been checked when they come out to look at your file. So next slide. So the commercial on that, only check yes to that when you need it for eligibility. And that's what that speaks about. You'd only need it is if you're trying to make them unlikely to return and their dislocation job is not from a declining industry or low growth occupation. A little peek behind the curtain, most dislocation jobs are either from a declining industry or a low growth occupation. In some instances, both. But one of the things about it, you get that actual, when I say you, the career planner in the guided application, they get that required additional assistance question before they record the dislocation job. So they might not know if that job's going to show up as low growth declining. So for some reason why you put a yes to requires additional assistance and then you record the dislocation job and see that the dislocation is either declining or low growth, you can just go back and remove that requires additional assistance, save yourself a little bit of paperwork and get a monitoring finding. So next slide, please. So to recap again, you have to be first laid off or notified of laid off. Then you have to be eligible to draw a monetary benefit or exhausted if you worked at a job that paid into UI, or if you worked at a job that didn't pay into UI or had insufficient wages, the client would then meet tenure. And then we have to look at that dislocation job. Was it from a declining industry or low growth occupation? And if not, can you as a career planner justify how the client requires additional assistance to receive the services because they can't go back to their previous job. So some other examples could be maybe for requires additional assistance. Let's say I'm a truck driver and maybe I have a medical issue or a legal issue that I can no longer drive a truck. It probably wouldn't be low growth declining, but you could justify in the assessment. So again, but I don't want to bypass all the eligibility. It requires the layers of eligibility. First, they have to be laid off or notified, then they have to be eligible for LWIA or meet tenure, and then they have to be the low growth declining or the requires additional assistance. But it all has to come together. And that's why it's so very layered. So I know it's confusing. That's the reason why what we have done, when I say we, the state with the dislocated worker policy, we've broadened what can be a substantial layoff. So if you can make anybody eligible under substantial layoff, you don't have to worry about all this layered unlikely to return. So next slide, please. So now if you can understand the ins and outs of unlikely to return, the rest of it is a piece of cake, because by far that's the most complex. So next slide, please. The next one, plant closure, substantial layoff. Next slide, please. Next slide. If an individual has been terminated or laid off or received a notice of termination or layoff due to plant closure or substantial layoff. So next slide. And this doesn't have to be a big plant. It could be a small business. It could be any business that's closing or having a large layoff. One of the things, as I touched on, our dislocated worker, they allow us to expand what could be a substantial layoff. And again, this is probably the most exciting portion of the eligibility policy. So next slide, please. It includes the traditional. If somebody has a federal, state, or local disaster, but don't forget COVID's a disaster. So if you can tie a dislocation job even still back to COVID, you can call it a substantial layoff. Also, anything that's a rapid response, either a state or local event, you can call it a substantial layoff. And then this last one, layoff and sector occupations that are substantial or significant to regional or local workforce or economy as identified by the LWIA. This allows local boards to make a policy identifying substantial or significant to the region or LWIA, and anybody that's listed in that occupation that gets laid off, you can call it substantial layoff. So this is a real game changer if your LWIA chooses to get a local policy. So next slide. And this just goes on, what does that bullet really mean? It's the layoffs, that sectors and occupations are substantial significant. So next slide, please. This was feedback from Kelly Lapatino, the Northern Regional Manager, and it was substantial in sectors and occupations should come from the local and regional plan documents. If the occupation sector is not listed in local plan, but there are other extenuating circumstances the board believes will impact the local economy, they can determine as circumstances warrant to include those layoffs as significant to the local economy. The circumstances should be defined in the local policy with a statement from the LWIA as supporting the documentation for the eligibility. And this is what we're talking about, being able to have the LWIA identify sectors and occupations that we can call substantial, even if the person doesn't meet the traditional criteria for substantial layoff. So next slide. To understand substantial, we'll talk about what is really a substantial layoff. Typically, like a trade, the people that work the trade program, it's like 50% of employers that's of a place. But we can also look at it to think, you know, if there's 3 shifts running and a company shuts down a whole shift, that's a third of the employees. That's a substantial layoff. Or let's say it's a small business. They have a small sales force of 6 people and they lay off 3 of them. That's half the sales force. So it doesn't always have to be something huge. If you're not sure of what something could be a substantial layoff, reach out to your supervisor. And if they're not sure, we got a rapid response team and you have your reps. And if you don't know who that is, I can help reach out and find the appropriate one. But we want to get their feedback. But we're really trying to be broad on what can be substantial layoffs. Next slide, please. And a plant closure substantial layoff, it's really easy for logic for IWDS. Next slide. IWDS is looking for it's yes to primary occupation, yes to dislocation, and yes to plant closure. Next slide. Or next to substantial layoff. That's the logic for IWDS is looking for. Is it your primary job? And is it a plant closure to substantial layoff? Next slide, please. An individual, this is how it's worded in the policy also, that if somebody gets notified of a layoff within 180 days, they can start receiving services also as part of a plant closure or substantial layoff. So within 6 months. So next slide. Something to understand about it, when you're dealing with plant closure, substantial layoff, UI status or tenure, none of that matters. We don't care about declining industry or low growth. We don't care about required additional assistance. It's just where they part of that we can call a plant closure or substantial layoff. So next slide. By far, it's the easiest or one of the easiest, just because you list the dislocation job, plant closure, substantial layoff. That's the entire logic for it. So next slide. Next, we're into timing here. There's a newest criteria. It's called UI profilee. So these are people that apply for UI. So they get laid off, they apply for UI, And the folks at UI have some sort of an algorithm they run, and they say, hey, we think this person's going to have a hard time regaining employment or self-sustained employment. So they profile them and they give them extra services. Well, when they do that, that makes them automatically eligible under UI Profilee. If they put an application in for WIOA within a year of being profiled, they're eligible as a UI Profilee. Now, the only exception is if they got a full-time job, but then they wouldn't be putting in an application. But if a person puts an application in that's been UI profiled, they should be determined eligible. We did find an issue this week where a client had been profiled from LWIA 26 and it wasn't showing up, and we're working on figuring out what went wrong. But typically, anybody that's been profiled should be showing up eligible as a UI profilee. So next slide, please. And how it allowed the UI profilee, it's actually a subset of the WIOA legislation, and this is just the eligibility criteria, so no need to read all this stuff. So next slide. But if everybody ever says, well, why did we become a UI profilee? Because it's allowed under the legislation. If you think about it, if I'm profiled, UI is already saying I'm going to have a hard time regaining employment. So that's going to meet that criteria. And the beautiful thing about for you as a career planner, if they're profiled, there's your eligibility. If it shows up in the tender application as a UI profilee date and UI eligible, then when you determine eligibility, you don't have to report a dislocation job. There's UI profilee eligible. The eligibility is within the IWDS system. The only thing you have to support is, are they authorized to work in the United States? And if they're born male, are they compliant with selective service? Everything else. So this is where that UI profilee report we'll talk about can really come in handy, because basically everybody's eligible as a dislocated worker. So next slide, please. Again, they have to be profiled within 1 year of their application for WIOA. But one of the things you have to put in their app, and you also have to do an eligibility determination for that to show up. So when you put their app in, when you see it says UI profilee yes and the date, that eligibility determination has to run before it's going to be determined eligible. So I get a lot of calls when it's like, hey, this person's not showing up as UI profilee, and then they run the eligibility determination and then they show up. So next slide, please. And when it shows up, it looks just like this, UI profilee. Next slide, please. And what happens with UI profilee, you have documentation and criteria. So next slide, the criteria basically just explains why somebody met it. Next slide, please. And then the documentation is next slide, is showing the specific choices. Next slide. Next slide. This is just authorized to work, has the different choices. Next slide. UI compliant with selective service. Next slide. And then this shows UI profilee. See, you have auto-populated verification of UI status. Always pick that. If you're really anal and you want an IDS UI profiling list, you can get that, but why do that? It's right in the system. So you should always be picking the auto-populated verification. So next slide. Yeah, I've just seen that question, Ray, that came in about UI profilee. Yes, if you have, like, when we're talking about the UI profilee list, next slide when you get a chance, Kristen. In a moment, if somebody's on that UI profilee list, if they put an application in within 1 year, next slide, please, of being profiled, then that individual should be eligible as a dislocated worker. So this kind of demonstrates right here when you certify, and this goes the same for all titles of dislocated worker. When you certify, they're eligible under 1D, 1N, 1S, 1E, 1DC, and 1EC. So any dislocated worker would be eligible for all titles. So this client was a UI profilee, as long as they were profiled within 1 year of whenever they put their app in. And it's actually when they get certified, they will be determined eligible. So next slide, please. And then you can start enrolling in services under any of those titles that you might have a grant. Like I used the example earlier, LWIA 18 had received some additional fundings. So if they received 1E, 1N grants, they could also use those for services. Now, sometimes there are restrictions depending on the 1E grant. It might only be for certain plants or certain businesses, but those are details that you'd work with your managers. Next slide. We talked about folks for Career Connect. They don't have UI profiling in Career Connect. They have to use the unlikely return, so which is under category 1 for you folks from LWIA 7. So next slide. The UI Profile E report, it gets updated approximately the 10th of each month. I'd highly encourage you to run this and do the most current people that's been profiled. Next slide, please. Where this can be found is if you have the reporting menu access, next slide. And it's under participant reports right in the middle, UI Profile E, next slide. And then you do it by your own LWIA, of course. You have a start and end date, next slide. And this is out of the training database because I didn't want to show real client information. So I ran it out of the training database. So next slide. On this, it just demonstrates, it gives the name, address, city, state, zip code, phone number, when they were profiled, and an email if they've provided. Most people I've found from IDS, they do provide the email because that's their communication with IDS. So you should get a pretty good PD or pretty good email contact for those to do direct mailers. So email blasts. You can run the UI Profile E by PDF, Excel, or Excel extended. So next slide. And when we ran that report just recently for the statewide, we used 7/1/21 through 6/9/25. Next slide, please. And what you have is what's called a data lag. The most recent somebody was appearing on that for being profiled was May 26th. So you got some data lag there. But this is by LWIA for that time frame. So we know every single person that shows up on that UI Profile E list would be eligible as a dislocated worker unless they found full-time self-sustained employment. So again, it's a great resource to reach out to use for soliciting clients, possible dislocated worker clients, because you know they're all going to be eligible. So next slide, please. UI Profile E, again, I already touched on this. It's updated on the 10th of each month or on or about. So next slide. Next slide. And again, it's a subset of unlikely to return. You're not required to record that dislocation job. If you know they're profiled, you can just put their application, complete the application without the dislocation job and determine eligibility, and they're going to be eligible. So next slide. Again, Career Connect, it's category 1. You don't have the UI Profile E. So if you come across a client using that UI Profile E list, you know they won't be eligible. You have to use category 1. So next slide. The next title is called No Longer Self-Employed. These are people that own their own business and that business closed either to general economic conditions, flood or natural disasters, or there's proof that the business is failing. They can start getting services. It can't be my secondary job and I decide I want to close that down and try to come in and get services. And it can't be just because I closed the business or sell it and I can get it. It's got to show those circumstances. So next slide. How it works in IWDS, the logic, it's looking for primary occupation, yes, dislocation, yes, and then self-employed, yes, and then either general economic conditions or next slide, please. Next slide, please. Or flood or natural disaster. That's what the logic's looking for. One of two of those layoff reasons. Next slide, please. For those who haven't closed yet their business, still employed, layoff pending, in process of going out, the logic could pick it up. So next slide, please. If eligibility also, it's funny, you can, if somebody works for a farmer on a farm or a rancher or a fish hatchery, they can use that. You just, next slide, please. You just have to check the block that says family member farmhand. Next slide, please. And that's off to the far right. So next slide, please. Next category is displaced homemaker. The next slide, please. The big thing about displaced homemaker is understanding this definition that's on this next slide. For an individual to meet eligibility, they must have been providing unpaid services to family members and who have been dependent on the income of another family member, but is no longer supported by that income, and is unemployed or underemployed and experiencing difficulty in obtaining or upgrading employment. So there's that underemployed we talked about before, where it's part of eligibility. So this is, if you think about this, it's typically, next slide, please. Oh, for logic for IWDS, it's simply a yes to that question. If you know somebody meets that eligibility criteria, You put yes to that question, they're going to be determined eligible under displaced homemaker. You would be expected to have the documentation from the person. So next slide, let's kind of talk about the circumstances. So most often you hear about it, or often you hear about unemployed or underemployed whose spouses get divorced, separated, they cannot afford a divorce from the primary breadwinner. Others could be spouses, they're unemployed or underemployed and their spouse had passed away. And then another one could be unemployed or underemployed, but the primary earner loses their job, and then the client would meet that. For this last, the third one, I would caution. Just recently, we had an LWIA. They put in the husband got laid off from his job, and the spouse met criteria as a displaced homemaker, and she started getting services. They were both in training, and the spouse that was working before got reemployed, and the spouse who was getting services as a displaced homemaker dropped out of training and said, "Hey, I don't need this service anymore because my husband's working now." So you really have to make sure that the person wants to work, because if we put them in and they choose to drop out of training or not work, it's going to hurt your numbers. I just want to give that little caveat from a recent issue that came up. So next slide, please. On this for documentation, if you just think about documentation, it depends on the circumstances, really. Is it for sure you're going to need the client's work history because you're going to have to show how they're unemployed or underemployed. And then it's going to be based on the scenario, whether it's divorce or if it's self-attestation because they couldn't afford to get a divorce, or is it a death certificate, or whatever to prove that the client or the spouse was laid off, whatever the circumstances, that's what you have to tie together in your documentation when you're utilizing this criteria. Okay,
We have
I
a
just
question.
see, and I do want to address the question that I just seen pop up. Go ahead, Ray, because I kind of seen it popped away real fast. So that
All
question
right.
about SSDI, that's a really good question.
Yeah, so this question's from Ashley. So the question is, what if they are both receiving SSDI benefits, they are getting a divorce, and one of them is now trying to return to the workforce?
Yep, and that's you had me with SSDI, because if they're drawing SSDI, they had to have been having some form of income themselves in order to draw, because for SSDI, that's where they had been previously working. So in that circumstances, it wouldn't sound that they can support that they've been supported by another family member because both were on SSDI. Now, if the one person was on SSDI and then they got divorced from the other spouse, well, then yeah, you'd still meet that circumstance. But if they're both on SSDI, it wouldn't meet that. And if I didn't get that right, feel free to send me a direct email if you have exact circumstances, because I first time I heard that question, so I wouldn't mind addressing it if I didn't get it all. But just for time constraints, I want to get through this last section. So if I didn't get that right, feel free to reach out. But again, if both were on SSDI, I think you'd have a hard time having that burden of proof being supported by the other family member and no longer supported by it. And no, the SSDI could not be considered underemployed. We want to stay away from, there was a question that popped up about could SSDI be considered underemployed? No, I mean, and you guys know it that work frontline staff. If you put somebody in SSDI, from what I've heard is, and people have done it, and then you get through services and then you can't get them to go to work because they got their SSDI benefits. So you want to stay away from those SSDI folks unless they got the work with the folks at the disability where they're getting released and you're really firm with that. But I've heard a lot of horror stories of LWIA staff that's put folks in with SSDI, and then the people don't work in and they're missing out on their performance outcomes. So now the last category we're going to talk about is spouse of an active duty service member. This is if you got a base or a naval base like up in LWIA 1 or Scott Air Force Base, this category could be a gravy train because every single spouse on that base that's unemployed or underemployed is eligible. If they're looking for a job, they're eligible. There's no other eligibility criteria. Show an ID that they're married to somebody that's in the military and they're unemployed or underemployed, and they are eligible for dislocated worker services. You could post things at every community college or every college in their area for spouses of active duty service member, and they're going to be eligible. So this is a gravy train. And all of you that's not near bases, every recruiting office, anything that's around a large university, they have ROTC units. These are eligible. When I spent 20 years in the Air Force, and I paid for my first wife to go through college. I wished I knew something about this. And I bet there's a ton of vets that are service members that don't know about it. So this is where outreach comes into play. So next slide, please. The criteria is really simple. It's really was set up for when people change duty stations. Like I said, I was in 20 years. You move every 3 to 4 years. It's really hard on a spouse because they have to pick up their job and follow their spouse with them when they're moving. So if they had to lose their job because they changed duty stations, but they even broadened it in the WIOA legislation. They said if you're a spouse of an active duty service member and you're either unemployed or underemployed and have a difficulty in obtaining the employment, you're eligible. So next slide, please. Because in IWDS, we made it pretty darn easy. If they say yes to spouse of an active duty service member, if they have a yes to either A or B, then they're eligible. That's your eligibility criteria. The documentation is the ID card showing they're married to somebody in the military, and then either their work history or deployment or work history of the client explaining which of those criteria they met. That's it. They're eligible. You can start serving as a dislocated worker. So next slide, please. Again, a yes to either one of those questions, and they're going to get picked up as long as they had yes to spouse of an active duty service member. So next slide. Next slide, please. So again, to qualify, it would be they're married to somebody that's in the armed forces, and then they lost their job due to transfer, or they're just unemployed, underemployed. I'll give you a little quick story because we've got a few minutes, I think, but I recently got contacted, and it was from an LWIA, of course, that forwarded it to me. And a young lady was married to a guy that was in the Army, and the guy had abandoned her, basically. But she was a spouse of an active duty service member, and she wasn't working. So she met eligibility. So weird circumstances because she wasn't with him, but she was still married. He had just abandoned her, and she met this eligibility criteria because she was unemployed, underemployed. So next slide. And again, the minimum documentation, you'd have to have that ID card showing their spouse. And again, these folks at LWIA 1 and 24, you've got a base up there, and there's thousands of spouses of service members. You just have to find a way to penetrate. There's a place called the Civilian Personnel Office that's on base. There's an education office on each base. Those are places you could go to post information about our program there. And then they'd have to show either unemployed or underemployed again. So next slide, please. So this concludes the different ways an individual could meet WIOA dislocated worker eligibility. There are 6 different ways. So next slide, please. And again, they overlap. So you got unlikely return to previous industrial occupation, and then you got plant closure, substantial layoff, UI profile E, no longer self-employed, displaced homemaker, spouse of a member of armed forces on active duty. Now, often you'll see a person will end up meeting eligibility for both UI profile E and unlikely to return. You often might see substantial layoff, unlikely to return. Again, whatever's easiest, but if they're certified, they just need to be certified in one, and they're eligible for all the WIOA services as supported by the assessment and what he or she needs to regain employment. So that's what you're looking for. So next slide, please. Within the updated policy, again, that was put out in May of 2023, it allows the LWIAs to define what can be a substantial layoff. So I just worked with Chicago. They've updated their policy, and they've got a really broad policy that's getting approved by their LWIB next week. And in theirs, how it's broken out is anybody that gets laid off from leisure and hospitality, manufacturing, trade, transportation, utilities, retail trade, accommodation, and food services can be considered a substantial layoff. So anybody that gets laid off from those, they don't have to worry about whether they're unemployed, as a declining industry, low growth, require additional assistance. By having their local policy break that out, everybody that gets laid off can be considered a substantial layoff if they fall into one of those industrial occupations. So that's the ability that those local policies that have to be approved by the LWIB, but they're worth the work to get those put in place. So especially for those that aren't serving as many dislocated workers as you hope to, you need to examine and work with your LWIB to create that policy. So next slide. So this concludes the presentation. So again, I'm still your contact just until July 31st. And then after that, you can send questions to Ray. Ray is super sharp. He is a statistical analyst. He comes from the banking industry, but he's going to be working with Mark Burgess for any questions that come up that after the 31st, if they're not sure, they'll do the research and they'll give you back good, solid questions. As far as what I owe for this presentation, I owe you a question, an answer, James, to your inquiry, and we'll make sure to get that to you, okay? I don't have anything else for y'all. If there's any questions, we'd be glad to answer it. And if not, I'll be glad to give everybody 4 minutes of their time back. Any questions, Ray?
Jim, I think we had one question from way earlier
Yep, go ahead.
from someone who's anonymous, but they asked what documentation used to show insufficient earnings.
Oh, it'd be their previous wages. So whatever they could tell you that they'd made previous, you're not going to make them bring in pay stubs. Just say, what was your previous earnings? And then what are you making now? And then you could, that's when you'd be looking at your local policy determined. I wouldn't get in the weeds of trying to make it like I said, bring it in. It's kind of, and you're looking for people. And again, it's going to be based on your own local policy of what self-sufficiency is. So a percentage of it. Well, maybe your boss is going to ask for more in depth that you get that feedback, but don't make it hard on the client. We're just trying to get him or her back to full-time self-sustaining. So if they made whatever 60 grand in the past and your policy is to get them back 100% of that, well, then we're looking for 60,000 more. If you feel like you need to get more formal documentation, the IBIS checks show up, or when they get into IWDS, they're going to have pre-enrollment wages that's going to show up. So you'll find that. And that's one of the things for those of you who may not have been around. When somebody comes into our WIOA services, if they don't tell us what wages they make, if they've had reportable wages, it's going to show up on the record. So we're going to find that information out eventually. So we're going to know. But for your eligibility for insufficient, I would just be asking what they previously made and then what they're currently making. You could draw that based on your local policy. So it is that time. I don't want to keep anybody past, so we're going to go ahead and shut it off now. I appreciate all of your time. And if I don't talk to you, it's been great working with you for those that have been around the whole 19 years. And if you have any questions prior to 7/31, feel free to send me a call or send me an email. Either one, I don't care. Either one works for me. So have a great day and we'll catch you someplace.